what you shouldn't talk about when raising money. So if you're out there doing a capital raise, if you've got a company, you're probably thinking about, what do I tell the investors? What do I not tell the investors? I'm Shawn McBride. I'm a business lawyer. I've worked at some of the largest law firms in the country. Started my own firm many years ago. And I work with companies on a variety of issues around ownership, equity, contracts, and particularly on capital raise. It's a frequent issue that I'm brought in on. So today I want to zoom in on, what do you tell the investors and what do you not tell the investors? The simple answer is you tell the investors everything that's important, right? So if you look at the guidance, it'll talk about material information that will change an investment decision. So you want to make sure you get everything out there in front of those investors that is important. This is leaning towards more disclosure rather than less. Now, if you're doing an offering solely with accredited investors and you're under one of the SEC exemptions, maybe like 506 of Regulation D, that is just a particular way that the SEC has said, if you follow these rules, you'll be exempt from having to register the securities that you're offering, the stock or whatever that you're selling. So if you're underneath that exemption and you have all accredited investors, your information requirements really are lower because there are not exact standards on what you need to do in that offering, because the accredited investors are in a situation where they're supposed to negotiate for themselves. However, you don't want to put yourself in a situation where you could be accused of fraud or of misleading the investors. So all of this points towards more disclosure. Plus, what I often tell my clients is you basically get a free pass on anything you put in your disclosure documents, meaning that if you tell the investors about problems within your business, if you really expose what's going on, and if you're honest and forthright with them, then the investor can't come back to you and say they didn't know that. So this creates a lot of tension, because if you have a problem or something that's bad, you want to get out there in front of it. You want to expose it. You want to show it from a securities law standpoint. But of course, that may hurt your investment. And the reality is, if you have such deep problems in your business, you don't want to hide it and have an investor find it out later. So what you want to do is sit down and talk with your lawyer and talk about what you're disclosing and what might be found to be material or important to an investor. And so what you look at there is, what other people are disclosing. The SEC guidelines are very helpful as to what might be material. Also, just general knowledge of cases and what other investors have deemed to be material all points towards disclosing those items. So you don't want to get those included in your disclosure documents. Now, walking away from that, you may find that you're in a situation where, you are uncomfortable with what you're disclosing. Now, this means either you're going to have to change your business or explain things more. You can't change the facts of what's there for the investment, right? So the material information is the material information. You could potentially fix an issue, maybe some litigation or other issue you're in the middle of. You could fix the issue through a settlement or otherwise and then make your investment look better, but that's going to take the passage of time. That's going to delay your offering because you need to tell the truth in the documents. So you need to potentially finish that litigation, get that settlement signed off, or whatever you need to do in order to protect yourself and your investors, right? So you can see all of this is a total blend of information in what you're doing, and you've got to balance the right balance. So hope that's helpful. Hope it gets you pointed in the right directions. For your questions, meet with your securities lawyer, sit down with them, talk about this, figure out what you're going to disclose, what's appropriate in your situation, and work with them to fine craft those documents so that those investors are getting true information, correct information about the business, and they know what they're investing in. If you have general questions or comments, and drop them below, including suggestions for future videos. Don't put anything there private, personal, confidential, because other people can see those comments, and we don't want other people seeing anything confidential as your business. There's no confidentiality in comments on social media, so limit your comments. But I do hope you subscribe to the channel, because we'll be back with more tips, tricks, videos, and things that'll help you. Look forward to talking to you soon.